Hello, this is Joel Whitney with the Syracuse University College of Law, and I'd like to welcome you to this edition of the New York State Science and Technology Law Center webcast. Today's webcast is hosted by Shubha Ghosh, the Crandall Melvin Professor of Law and Director of the Technology Commercialization Law Center. Shubha?
Thank you, Joel. Thanks for all your help. And I'm really delighted to have our meeting today and introduce Professor David Hricik of the Mercer University School of Law and of Counsel at Taylor English and Duma. He is one of the leading experts in certainly patent ethics and patent practice and patent litigation. I'm delighted to have him present his paper on Will Patenting Make as Much Sense in the New Regime of Weakened Patent Rights and Shorter Product Life Cycles. And I hope to have a discussion and get questions from the audience as they come in, but this is largely Professor Hricik's show for the next hour or so, and I'll try not to interrupt too much. I do have some questions and thoughts, and so I look forward to engaging as well. Just to give some further background, Professor Hricik received his undergraduate degree magna cum laude in Phi Beta Kappa from the University of Arizona, where he majored in English. And then he received his law degree with honors from Northwestern University School of Law, and then practiced with Baker Botts and small litigation boutiques from 1988 to 2002, litigating cases primarily involving patent infringement, legal malpractice, and general complex commercial matters. He's been teaching at Mercer since 2002 and then took a leave of absence to be a clerk with Chief Judge Randall Rader of the Federal Circuit. And then he did that from 2012 to 2013, and after that he returned to Mercer and assumed a counsel position as well at Taylor and Duma. Lots of accolades here, elected to the American Law Institute in 2016. He's the author of the only treatise on ethical issues in patent litigation, and has co-authored several articles both for practitioners and scholars in the field of patent litigation, patent policy, and patent practice. So David, welcome. I'm glad you were able to fit us into your busy schedule. Thank you so much for doing this, and I look forward to your presentation.
Thanks, Shubha. I appreciate it. And I always, whenever I'm introduced, I just think, I'm just this kid who grew up in Arizona, and somehow here I am. I started doing patent litigation in 1989, and I remember in 1996 giving a talk about ethical issues in patent practice, and I said to the audience, this boom has to end sometime. And 20 years later, maybe that's where we're at. And I'll come back to that point and talk about what I've seen. And let me tell you how I got to this topic and this paper and where we're going to go. I was asked to give a talk at Vanderbilt about technology and its impact on patenting. And I honestly knew some things, but I did not know as much as I know now. And what I want to present to you is the two things, or two and a half things, if you will, that I see coming together that are going to maybe make patenting make less sense, and then talk about some things that, as a lawyer, you might want to consider doing now. And I know Shubha, there's some broader policy questions that you've talked about, and they're also addressed in the paper. But the two things, or two and a half things, I see coming together are on the first slide. There is a weaker patent regime, and I think we all know that, and the paper goes into excruciating detail about this. But I was really surprised when I sat down and cataloged what has happened in the last 20 years, and starting 18 years this century. The patent system is remarkably weaker, and I will run through those at a fairly quick pace because most folks who are listening, I assume, know those things. The second thing that is happening is that products are having shorter life cycles, and we'll talk briefly about why that is so. That also means that it takes less time to bring an infringing product to market, and there's a lot of literature, and we'll talk briefly about it, but it's in the paper, that basically, if it takes a long time to develop a new product, that's going to be on the market longer, and it's going to take somebody a longer time to copy it. Well, because of technology, more products are coming to market more quickly, and those copiers are getting on board more quickly. That has implications for patent practice or the desirability of patenting that we'll talk about in a second. And then the 2.5 things is 3D printing. And there's been a lot written about it, but I will point out some things that the audience may not know and some things that lawyers need to be thinking about today because of the rise of 3D printing. And I want to be clear too, because when I was thinking about this, I thought, there's lots of reasons to get a patent. One of the reasons, and the reason as a litigator I always thought about them, was if I have this, I can sue somebody and I can make money for my client. Well, I went and looked and read the available research out there, and it's about 90% of patents that go to businesses. And somebody did a study, why is it companies that you go get patents? And I'm paraphrasing it because they use some bigger, fancier words, but one of them was to earn money, either by bringing an enforcement suit, seeking to license it, cross-licensing, things like that. Another one was for defensive reasons. If you sue me, I'm going to sue you back because I have this patent. So I branched that under the idea of defensive. The other thing, I don't know what you want to call it. I called it the trophy effect. Literally, if I came up with an invention, why would I want to get a patent? Well, I can put it on my wall and it's a nice looking thing. A credential. Someone recently wrote a paper where they characterized that as a credential. The other part of the trophy effect, though, is to attract investors. And a lot of startups will tell you, in order to get investors, I need to show them that I have intellectual property and it is protected and it's protected by patents. So that is what I kind of lumped under this idea of a trophy effect. And then finally, some of them said it's to block competitors. I want to get a patent so I can stop people from making copycat or similar products. So those are the reasons why companies get patents. Now, only one of those is really the focus, right? Even if patents are weak, it might be nice to have one on my wall, even if it's not worth anything. I'm focusing really in on the idea of the first part there, earn revenue, and the second part, block competitors. You may still want to get one to have it on your wall. You may still want to get one as a defensive thing. You may still want to get one because investors will want to see them. But I called it the coercive benefit of making somebody pay you money or getting an injunction is really what I'm focusing in on when I talk about the weakening patent regime and how it reduces an incentive to patent. So what this study also showed was there were reasons why companies didn't get patents. I said to them, why don't you apply for a patent? And again, I'm lumping these together a little bit, but they said, well, there's some uncertainty about whether what we come up with is patentable or not, right? And so if there's risk, you go through the process, you spend a bunch of money and we don't get anything, it's not worth trying. Prosecution's expensive, litigation is expensive. They said, we're worried because claims can be designed around. And we come up with a patent, but then our competitor can make a small tweak and avoid infringement. That's not good. We just wasted a lot of time and money. In order to obtain a patent, you have to provide to the public how to make and use the invention. That may require disclosure of trade secret information or proprietary information, and in the cost-benefit calculation, that's one of the costs that they take into account. And this is kind of related to that. There are other forms of protection available, and usually that's going to be the form of trade secret protection. Rather than disclosing how to make and use it, to some extent, we can go with the alternative of using trade secrets. So now think about those reasons when we go through this quick catalog of what's happened in the last 20 years. Patent rights have been weakened, and I read a lot of people's opinions about this, and I don't think there is a reasonable debate about the direction to which patent law has gone. Patent rights are weaker. The degree, you could fight about some of that. I don't know if we have enough data, and I'll come back to that point in a little while. But I don't think it's a reasonable argument to say patents are stronger today than they were in 2002. The Supreme Court has done some things, Congress has done some things, and even the state has done some things. Now again, I'm not going to go into a lot of detail about these because most of you know them, but what was personally kind of breathtaking to me was when I sat down and I went through the Supreme Court cases and to a minor extent some of the decisions from the Federal Circuit. It's like they had a hammer and were trying to beat up patents, and they did it in every way, shape they could every time they had a chance. There were
David,
some exceptions. Yeah,
can I ask a quick question just to give some more background to our audience?
yeah.
So what is your starting point for making the comparison of weekend? You mentioned 2002, which I can understand. Is it 1982 when the Federal Circuit was started? Was it 1952 when you had the big patent reform after World War II? I mean, certainly they're stronger now than they were 100 years ago, weren't they? Or would you say that have we gone back to the situation before World War II, or are we in just a totally new world, or is it just simply we're back to where we weaken
It's an
positions?
interesting question. Interesting question. I won't get into too many rabbit holes, but I think our Section 101 analysis has now gone back to prior to the way we used to look at what we now call obviousness. Prior to 1952, I think we literally are in 1945 as far as that goes. I haven't thought about that enough. I wouldn't say that apart from Section 101, I think we're back that far in terms of regression. But I think this is how I think of it. I kind of took a baseline of let's look at 1982 and what happened, and I think everybody agrees that when the Federal Circuit was formed till 2002 is the time when I picked because that's when Festo was decided, and that's the first Supreme Court case this century, and that was kind of my demarcation point. I think everybody would agree that the Federal Circuit stabilized patent law and made it better. Then you have a shift that the Supreme Court began in 2002. I don't think that shift has taken us all the way back to pre-1952, but we made a U-turn. We haven't turned all the way back to 1982, but we're heading that direction, I guess is where I would say. And again, look at and you can argue about the degree of these things. And again, there are some exceptions, but almost always when the Supreme Court has taken a patent case, it's reversed the Federal Circuit's approach and adopted an approach that is more hostile to patents in one way or another. And I'll show these chronologically later, but I just wanted to kind of lump them in terms of subject matter effect. Well, it's harder to get a patent. And y'all know if it's harder to get a patent, that also means it's easier to show one is invalid because they're mirror images of each other or the flip side of each other. So you had Section 101, which I think is probably the change that's resulted in the most number of patents becoming, quote, invalid. And I put that in quotes because I don't think it's a basis of invalidity, but ineligibility or whatever they want to call it. The reason for that is it's allowed for sort of a very light analysis of Section 103, right? You have judges saying, well, it sort of looks like this is something people would have known without going through the rigorous analysis that Section 103 requires. We don't do the kind of analysis that we would require for analyzing whether there's support for claims. Instead, it's just, wow, that's broad or that's abstract. And so you're allowing a short circuit of the kind of analysis we would do. So that's why I think it's 101 is a real problem. And let me be real clear about this. This may be a good thing. I'm not making a judgment about whether patent law had gotten too favorable to patents. I don't know. Well, what I am saying is it's weaker. Maybe the Supreme Court is correct in every single one of these decisions, and they got it right, and the Federal Circuit got it wrong. I don't know, but it's the direction that to me is important because as lawyers, we need to be thinking about patenting as an alternative given the weaker situation we're in. The other thing that 101 is allowed, and it amplifies what I just mentioned, is there's no presumption of validity. I remember I was at the court clerking when the second ultramercial decision, I forget where it was, and the court issued an opinion that said there's a presumption of validity and you usually are going to have evidence because that's how this system works. And that got changed later, and we now have a lot of times 101 being decided on 12b6 on the pleadings. Which if you think about it, so the patent office issued it, and it's so clear that a judge can read the patent and decide that it's invalid as a matter of law. That's a kind of a stark change from where we were just a while ago. Business methods have been, found to be abstract. Some of these cases, though, concern me. I mean, the formula to determine the metabolization rate of a man-made drug is a natural phenomenon. And just think about that statement for a second. A method using, this is the Ariosa versus Sequenom case. They discovered that pregnant women had free-floating fetal DNA in their blood. Nobody had known it was there before. They realized once you knew that was there, you could use existing technology to get better results than the previous tests. Safer, better, more accurate. Changed how they did those tests. Oh, well, that's a natural phenomenon you're using with conventional methods. So therefore, even though nobody had ever thought of this, people were shocked, changed the way they did the industry. That's not eligible for patenting because you're using something from the human body. That's breathtaking. And I know friends of mine who do biowork and pharma work are like, holy cow. I mean, they were shocked by that case. And when the Federal Circuit didn't take it and grant cert. What happened also to make it harder to get a patent and again easier for it to be invalid? Well, the Supreme Court said the Federal Circuit had said there had to be a teaching, a suggestion, or a motivation in the prior art to give you a reason to put two things together to make the claimed invention. To put it, simple language. Well, the Supreme Court in KSR said, well, common sense is enough. Well, the impact of that, there was a study I found, and it said that patents are 7 times more likely to be found obviousness after KSR than before, which again means it's harder to get one. What I've seen is what examiners will do this drives me nuts. They'll do what they're called single reference 103 rejections. So an examiner will say, here's a prior art patent. Your invention is different than what's in here, but using my common sense, I can come up with your invention. That is really strange. We used to say 102 was it had to be identical. 103 was you had to have 2 pieces of prior art and some kind of reason to combine them. Single reference 103 rejections are now, I don't want to say common, but I've seen more and more conversation about them. And that to me is disturbing, along with, again, the reduction, if you will, in the standard of, or the increase, I guess is a better way of putting it, in the standard of how much inventiveness is required. And again, is this a good decision policy-wise, a bad decision? I don't know, but I do know that it's now harder to get a patent and it's easier to invalidate one. The Nautilus case, it said indefiniteness is easier to establish. I don't know how much, that's impacted it, but we went from if the claim is, unless the claim is insolubly ambiguous, it's okay, to it has to provide reasonable notice. So it's an easier standard to show indefiniteness. So again, it's easier to reject a claim, and easier to show that it is invalid if you did get a patent. Now, what if you get a patent, right? You got a patent.
Can I ask one question here before you move on to the infringement? Is that okay? I think we have plenty of time.
Yeah.
So just to go back to the slide before, I mean, I'm not going to disagree with you that patents in some sense are weaker. I'm just trying to understand a little bit here, and I think other people may have this question as to, is it the Supreme Court that's the problem? Is it the Federal Circuit, or is it the PTO? So, for example, on invalidity, I was kind of surprised when Supreme Court granted cert in Alice, or they granted cert in so many of these 101 cases. But it seemed like if you go back and look at the Alice en banc, it was kind of a mess. I mean, the Federal Circuit almost was trying to invite review by the Supreme Court for whatever reason. And if you go back to Bilski, whatever you say about machine transformation, there obviously, I think what the Federal Circuit was trying to do there was correct some confusion in the USPTO about is it a European-style standard for technical art, or is there a distinctly American standard, a U.S. standard? So what would you say a little bit about that? I mean, so for example, take another example with the non-obviousness and the teach, suggest, motivate. I think one of the criticisms of teach, suggest, motivate, was there are a lot of patents that were rolled out that seemed they put the burden in the wrong place in terms of showing who had to show the teach, suggest, or motivate. In other words, that if it didn't teach, suggest, or motivate, that then became the basis for showing that it would be non-obvious. It seemed like a very, I don't know what the right word is, just kind of a case that was too knife edge in some ways.
Yeah, and to go back, first of all, I was there when Alice issued, and I can't say a lot about it except I don't think they were trying to invite cert. Without revealing what I know. As somebody who sat down and tried to figure out what the Supreme Court cases meant and spent a significant part of a lot of my life reading and rereading all of the Supreme Court 101 cases.
Yeah.
I think I could say the Supreme Court had made such a mess of it that there was no way for the Federal Circuit to have an answer. Because it is, I think, I don't say everybody, most people would say that it's at least incoherent, the Supreme Court's 101 jurisprudence, which led the Federal Circuit to be incoherent, I think might be the...
You mean the jurisprudence going back to Diamond versus Chakraborty, or even before then?
Yeah. No, even before that, there was a case oh good Lord, it actually was discussed in the hearings about why they got rid of 101 as I don't want to get too much into the weeds, but in 1946 Congress did a long study back in the early 40s about the inventiveness standard, and there was a lot of this all the discussion that we're now having had been in the cases in the early 40s. And Congress held a hearing, and what they basically decided to do was to get rid of the idea of invention as a test for a condition for patentability. And they rewrote what was then Section 101 and broke it into Section 101, Section 102, and Section 103. And when you read the hearings, I think it was pretty clear that what they wanted to do was get rid of any kind of idea of there was not supposed to be anything in 101. Everything was supposed to be in 102, 103. I mean, I think it's as far as substance. If you read 101, it says you may get a patent. 103, it's a difference. Very, very different statutes. And if you go back, there was a case, and there was discussed at the hearings, and I don't remember the name of it, but it was one of these natural phenomenon type cases, and Congress spent a lot of time talking about it and trying to figure out, and I think they thought they had solved the problem that we're now dealing with. But your question of did the PTO, I'm sorry, the Federal Circuit and the PTO make 101 too small of a bar, so we had a bunch of abstract, broad patents come through? I have no doubt about it. I've seen them. I've probably represented patent owners who had them at some point. Is that a problem that we can address by using 112 and 103? Absolutely. That, to me, is the solution there. It's not doing what we have done, which is to unmoor patent law from the rigorous kind of analysis that we normally would do under 102 and 103 and throw it into, it looks broad to me, or it looks like it's conventional to me, and letting a judge decide that based on the pleadings, or by reading the patent. You're right with 103. Maybe the bar was too low with TSM, requiring that. But what I hear practitioners telling me is they'll get a rejection from an examiner, and he says, well, he didn't say it quite this way. In my opinion, it's obvious. Okay, but how do I argue with that? I mean, the idea is that the examiner is supposed to establish a prima facie case of obviousness that would then create the obligation to come forward with secondary consideration evidence and whatnot. But if the examiner can just say, based on a single reference, I would have figured it out, how do I argue with that? That's without pointing to objective things like prior art. So it's, the pendulum has gone the other direction. Was it too far? I don't know. Is there a better solution than what we have? Probably, and we'll probably get there someday.
Yeah, I mean, the hard issue there, I mean, one of the parts of that is the examiner is now standing in for the FACETA. The examiner is saying, the examiner is essentially saying, I'm the FACETA, and therefore it's obvious to me, which is not the right way.
Yeah, and examiners get paid based on counts, and if the examiner can reject it, they earn their count, and that helps them move onward. So there's a lot of things about the way things are now which I wouldn't say we've moved. I don't know if we've gotten better. We moved sideways in terms of things. You know what I mean? It's easier to show obviousness. Maybe it needed to be easier, but it created other problems that maybe could be avoided through some other changes.
Yeah, I think later on in your slides, I'm sorry to interrupt, but later on in your slides, you'll talk about some of the cures, and one of them certainly is in terms of the administrative deference or review of what the USPTO does. I mean, that's certainly something that's coming under scrutiny.
Yeah, and there are things that we could possibly do in other areas, like for example, should the presumption of validity be so strong, clear and convincing evidence and so forth. I mean, there are things you could do that would help to eliminate bad patents without giving kind of free rein and making it very unpredictable. I mean, my understanding from talking to certain practitioners is, and then again, one of the reasons why people don't get patents is, I don't know if I'm going to be able to get a patent. I have this revolutionary new way of solving a huge health problem that involves something I've discovered about the human body, and it's so wonderful that you can use existing conventional technology. I'll use a silly example, and I'm a bad example because I don't have any hair. But what if somebody found out that, if you pull a piece of human hair and you hold it at the right light and you dip it in water for an hour, you can predict with 100% certainty whether that person will get cancer. Well, hair is a natural product, water is natural, and you're using a conventional method. They could change the world and save lives and get nothing because it's easy to do. On the other hand, if they come up with a really expensive, complicated way, right? You have to invent a new machine to look at the piece of hair, and you have to invent a new chemical that's never been used before to figure out whether now you can get a patent because it's really hard and complicated. But if it's simple and elegant and cheap, nope, I'm not going to give you one. That just to me is crazy, but that's where our system seems to be headed. And I can understand why if I'm somebody applying for a patent, I'd back off from that. Which, again, that's bad. I want people to cure cancer. Do I want people to have patents that say we claim cures for cancer so nobody can cure cancer? No. There's a real balance issue here, and I think, again, my point is we went one way. We are definitely heading away from patenting.
I guess the more complicated technology might create more jobs. I mean, if you have more steps, I mean, if you're viewing it from a pure economic utilitarian perspective in terms of what the spin-offs might be, I mean, that dynamic is here, I mean, especially in this day and age.
Yeah, and I agree with you, and I think there's some real big policy issues, but should it be mild court, the Federal Circuit, or the Supreme Court? Or should it be Congress making these decisions about 101 and what it means, for example? And there's a lot of very difficult issues that I don't think the federal courts are necessarily best equipped to decide. That's a broader issue too. So let me talk about infringement, because this is another one where, again, going back, and this was I started with FESTA because it was 2002, and that was kind of my starting point here, but prosecution history estoppel is easier to find and is harder to overcome after Festo. So again, remember, one of the reasons why businesses don't get patents is they're worried about designing around claims. Well, Festo made it easier to avoid infringement under the doctrine of equivalence, so guess what? You're going to have problems with getting infringement. This is, you could argue this is neutral, right? The Supreme Court said that sometimes some parts of claim construction involve factual issues, and if so, the Federal Circuit should defer to the fact findings in that context. So you could just say, well, that's neutral. It's not anti-patent. If you look at it from the perspective of the Federal Circuit is pro-patent, this diffuses their power, right? It takes away power to some extent from that court to decide what a claim means and gives it to a district judge who may not be as pro-patent. But it's sort of neutral in one sense. But that means that it might be to that extent harder. There were two cases where the Supreme Court addressed when is it that overseas activities can constitute infringement of a U.S. patent. In both cases, the Federal Circuit had given an expansive view of infringement conducted overseas. In both cases, the United States Supreme Court took them reversed and gave a narrower construction. And again, to what extent does that matter? You could argue about it. Inducing infringement, exact same thing. Two cases. The Federal Circuit said you can find inducement under this fact and that fact, and I'll run through them again at the very end of all this. Supreme Court granted cert in both of them and took a narrower view. Again, maybe the Federal Circuit's interpretation of the statute was wrong. I don't know. Maybe the Supreme Court's policy view is better. I don't know. What I do know is if you own a patent, it's harder to find infringement for all of these different reasons. And there's still more, right? The Supreme Court has decided 2 exhaustion cases this century. In both of them, they reversed the Federal Circuit's approach. One case, they said you can exhaust a method claim. In the other case, they held that activities overseas can exhaust a patent rights in a product. Both times, again, I was sitting there, I thought, well, that's not really infringement, but you're right to say that activity or product infringes ends with exhaustion. So I kind of lumped it under the idea of infringement. So it's harder to get a patent. It's easier to invalidate one. If you get one, it's harder to show infringement, and fewer activities are going to infringe or constitute induced infringement. And it's easier to lose your rights to sue for infringement through the idea of patent exhaustion. Then you get, what if you get your patent and you're like, well, I got this patent and I'm going to file my lawsuit. Well, we just kind of talked about how it's harder. It's easier to show it's invalid. It's more difficult to show that there's infringement. And what else? Well, there's some procedural changes that happen. And some of these, I know some people think, well, who cares? But this first one especially, I think, has had a bigger effect than maybe people appreciate, because maybe I'm sensitive because I was in this boat once. It used to be you had Form 18. You had all these forms following the rules of civil procedure. In Form 18, all I basically had to say was, I own a patent, and you make something and it infringes it. And that stated a claim upon which relief could be granted. We would go into either our local rules and deal with mandatory disclosures, or we go into discovery depending where we were. Okay. Well, why does that matter that now I have to meet the Iqbal-Twombly standard? I have to plead, putting it in a nutshell, facts or factual material which, if true, show there's infringement. Well, if it's a product claim, I can buy your product and do my analysis, and I can meet that pleading standard. But in method claims, if you're performing a method in your factory, for example, and you're the defendant, it's going to defeat or make it very, very difficult for me to do my Rule 11 analysis and file my lawsuit. And this creates some real problems, not in all cases, in the marginal cases where I cannot get enough information without filing, to get my complaint to file the lawsuit, I'm not going to be able to file that lawsuit. So even though it's a procedural change, it really did affect the ability, in some cases, particularly method claims, to be able to file that lawsuit, because you're not going to be able to have the information that you're required now to put in your complaint. And again, I had to deal with this once. I mean, we really could not figure out whether the method was, whether we had a good faith basis for saying the method was being performed. We couldn't go trespass and go look. So we were in a very difficult place. That's just one of those issues that this creates. The next one's a little bit marginal. The Supreme Court said that, reversed the Federal Circuit and said that a licensee doesn't have to stop paying in order to create declaratory judgment jurisdiction to challenge the validity of a patent. The Federal Circuit had said they were stopped. Their only choice was stop paying on the license, keep doing it, then you'll be infringing, and then you can bring your lawsuit. The Supreme Court reversed, so it increases the number of challengers. Marginal, but it's still, again, going the other direction. The next case, of course, has made a lot of headlines with T.C. Heartland, with, I don't know if dismantling is the right word, but certainly making it harder to sue in places like the Eastern District of Texas and the Eastern District of Virginia, where are viewed as pro-patent owner either because they're fast or for other reasons. That makes it harder to file lawsuits, and I know that the Federal Circuit just granted mandamus in, drawing a blank, the case the other day where they reined in one of the cases from the Eastern District on trying to give a broad definition to regular place of business. So if I have a patent, now I need more information to file my lawsuits for infringement, and I'm going to not be able to pick the better district, if you will, for doing so. And then finally, I also have, Octane. And again, you can argue that Octane Fitness is neutral. Octane Fitness is the case that said the Federal Circuit was too rigid in its requirements for showing that a case was exceptional and shifting attorney's fees. Okay, but let's back up. The threshold is that you have to have lost the case. Well, if it's now easier to show invalidity, and if it's now harder to show infringement, it's more likely that the patent owner is going to lose. So Octane Fitness, while it's neutral, if you think in the direction that patent law has gone, it's made it riskier for the patent owner to file the lawsuit because it's more likely they're going to lose. So that case neutral, but when you think about it, probably cuts against the patent owner. And then this to me is the real big picture, and as a lawyer representing folks, in fact, I was talking to a client the other day who was thinking about filing for a patent, and I said to him, let me tell you how this is going to work. You're going to get a patent, maybe, and turns out I didn't think he had something he could. It turns out we did a search and he didn't have something that I thought we could get a patent on. But if you get it, then you're going to be able to file a lawsuit, and the other side's going to be able to say it's invalid, we don't infringe, and you got all these things. And then what they're going to do is they're going to rely on these new post-grant proceedings. And this is when I think this has really probably been the biggest change, because it amplifies the substantive weakening of patent law that the Supreme Court has done. And it also then has procedural things built into it that amplify those even more. So what do I mean by that? And I know, by the way, there's differences between covered business method and IPR and post-grant. And I'll talk about the trade secret thing in a second, because it's a different issue, but it's related to why the incentive to patent has gone down. With post-grant proceedings, that's the first two things combined. But when you give a claim the broadest reasonable interpretation, you're making the bullseye bigger, right? In litigation, the prior art is going to have to meet a smaller circle. It's going to have to fill, I don't know how my camera's over here. Here's my claim in litigation. It's this big. You better have prior art that's inside of that, or it's not anticipated, or it's not obvious. If we go to BRI, the target's bigger. It's easier for you to hit the bullseye with prior art because my target is bigger. The other thing is we do not require, so far the PTAB hasn't relied on this doctrine that we should construe claims to be valid. That's often said in litigation. So we have a broader claim, bigger target. We don't try to construe it to avoid the prior art, like as is often said in litigation. So we're going to end up with a bigger target to hit. Then you add that next part. It's not clear and convincing evidence. It's only preponderant evidence. There's no presumption of validity. Now I've got a big target, right? And it's even made bigger because you don't have to show clear and convincing evidence. It's merely preponderant evidence. So you take those two things together and then you add on top of it KSR, for example, or 101, or you guys be protected by the doctrine that you construe the claim to avoid invalidity. It's not going to be protected by the requirement of clear and convincing evidence. And it's going to be subjected to weaker standards for invalidity. In other words, a patent that issued in 2005 will be judged now under KSR, which I think came out in 2006 or 7. So this is a huge shift. The fact that, and I know this is changing, the fact that the PTAB has made it harder to substitute claims, say, hey, look, that one's might not be valid. Let me narrow it down. That means my patent is in jeopardy. So now back up. I'm going to sue you. You're immediately going to say, no, we're going to throw this into IPR. Then what's going to happen is it's more likely my claim is going to be read in a way that's going to find it to be invalid. And we're not going to require clear and convincing evidence. And I'm not going to be able to fix it because I'm not likely going to be able to substitute claims. And then finally, the real gotcha is the last part, staying litigation. What is going to happen? The protections of clear and convincing evidence, the protections of reading the claim to avoid the prior art are gone because my litigation is going to be stayed and the PTAB is going to decide whether this patent is valid or, well, whether it was patentable or not. They don't decide validity. And then there's a study in the paper that shows that the Federal Circuit is much more likely to defer to a PTAB finding of unpatentability than it is to a district judge or a jury saying invalidity. So if you really look at where we are, we have weaker patent protection, and then we have it taken the protections of claim interpretation from the rule that you try to avoid invalidity, and the protection of the presumption of validity through clear and convincing evidence are effectively gone. They are effectively taken away through PTAB. And obviously, again, on top of all that, it's cheap, right? I think they're running, what, $250,000, I think is what I've seen for a PTAB proceeding. The good news, by the way, is the cost of litigation, patent litigation, has gone down. Why? Because these cases go away because the patents are found invalid on PTAB proceedings. So the AIPLA actually said that patent costs have come down a little bit, which I guess is good.
David, what's your experience with settlements in the IPRs? I mean, another way that these things could go away is if the parties settle at that phase. And you do see, not that much, but you do see, double-digit percentage of cases settling. It's not like 50% would settle like you might predict in civil litigation. You do see.
Yeah, and it'd be a value to talk. Yeah, no, they do settle. I've been involved in some of those. The problem is you're settling at a discount because of what we just talked about. The other thing, though, is I think there's a case in front of the Federal Circuit now about this, but the way the statute is written, the USPTO can carry on. And so settlement doesn't necessarily mean that the proceeding will end, no matter what the parties want. And I think even the PTO can intervene in ongoing litigation about the patent. So you're right. We get thrown into IPR, and it will result in settlement at a huge discount over what the patent was worth beforehand. And again, maybe that's a good thing, right? Maybe patents were overvalued and given too much protection, and people were extracting ridiculous rents from worthless pieces of paper. I don't know. I mean, it's way over my pay grade to figure that kind of stuff out. I just know as a lawyer, like when I was talking to this client, I'm like, if we get you a patent, what you're going to be able to do is file a lawsuit against somebody, and we got to be really careful. If again, we didn't apply for a patent, but if we go through that process, we got to be really careful, because if we narrow our claims, we're going to lose coverage. Once we get out and pick a target, they're going to throw us into an IPR, and all of this, we're going to be back where we were, and we're going to be in front of the patent office for a while, and that is going to delay us. And I'll come back to on this slide it talks about the stay. They're going to stay the litigation for a year and a half, and if we come out of it, and if we succeed through all that, then we'll get to come back. So you're going to be 4 or 5 years from now, we will be in front of a jury, maybe 5 or 6 years from now when we add in patent time. And that's a pretty stark conversation to have with somebody who's thinking about spending $10,000, $15,000, $20,000 to get this property, quote, property right that they want.
You may have mentioned this. There's another slide. There's also the eBay case. I think it's in the paper, obviously, but the eBay difficulty of getting preliminary and permanent injunctive.
Yeah, and the state stuff, there's these anti-troll states things, and they're not, if you're sending frivolous letters to people, you should pay money. But they are another way that patents have become riskier to own, riskier to enforce. But if you're writing a bad faith letter, shame on you. Right. But they are out there. So where are we, right? They made the substantive law, Supreme Court has, and again, I don't know if they're right or wrong, but it is certainly more difficult to get a patent, easier to show one is invalid. That next paragraph to me is just what is often overlooked. Because litigation is stayed, you're going to end up in the PTAB. You're going to be looking at this weaker law from KSR and Nautilus and those cases. Weaker law, a broader claim without the presumption of validity. So that's where you're back to. So I don't know, again, if we're back to 46 or not. If you lose, right, which is more likely now, it's easier for the other side to say, well, pay us our money. We spent $500,000 defending this. Pay us, because your patent is invalid, ineligible, wasn't infringed. What if you win? This gets to your point. All right, we won. eBay. I went back and read. I'm probably like you. I read eBay 20 times in my life, but I hadn't read it in 5 years. And I went and reread it the other day, and it really doesn't say how it's being interpreted. I wish they had just said, look, a patent is a property right, and so the general rule is that you will get an injunction, but that's just kind of a starting point. The language they used was unfortunate, and what is more unfortunate is the way it's been interpreted. In the paper, I went and looked at studies about what's happened to injunctive relief, and courts are more often denying injunctive relief, particularly to non-practicing entities. I don't remember the statistics that I found, from the studies off the top of my head, but that's remarkable. And again, one of the reasons why businesses get patents is to block. Well, if I'm talking to my client, I got to say that's not going to happen. If you're not making this product or a product like it, you're not going to be able to block it because non-practicing entity. Even if you are, the courts are sort of saying that's not the normal rule. And again, I thought it was amusing. I went and Googled. I searched for the word, right to exclude and things like that in Supreme Court cases. And, they say it all the time. A patent gives you the right to exclude. Well, no, it gives you the right to sue for money damages and to possibly, under certain circumstances, get an injunction. That's a big shift. And the leverage that you would have had back in the day is weakened because of this change. It's also weakened because patent protection it's easier to show invalidity. It's weakened because it's harder to show infringement, and it's weakened because of the PTAB proceeding. So the idea that it's the right to exclude is more of an illusory part of this. It is a right to maybe 5 or 6 years after you get a patent to, if you are lucky, argue you should be able to exclude somebody from competing. These other cases, I don't know how much, Apple versus Samsung was the design patent case and design patents. And I threw in, and you'd ask me, how much is this the Federal Circuit? The Unilock decision where the Federal Circuit said this 25% rule is crazy for what portion of profits should be awarded to the patent owner. That made a big change because it got rid of this silly idea. But look at that overall. You've got the equitable relief is less likely to be granted, despite what I think eBay really said. The Federal Circuit made reasonable royalty damages harder to get. It's always hard to get lost profits. It always has been because of the need to show causation. And so even if you succeed, you're not going to get as much as you would have a few years ago. Now there are some changes, right? Octane did make fee shifting easier, so if you do prevail, you're more likely to get the other side's fees or get them to pay your fees. Halo made it easier to show willful infringement. The Federal Circuit had made the Supreme Court doesn't like rigid rules. The Federal Circuit had a big rigid rule, and so they said no, it's easier to show willful infringement. So if you win and if you show willfulness, then you're going to get more likely you'll get enhanced damages. And then, I don't know how much this would matter, but the SCA hygiene case, the Federal Circuit had said latches can sometimes bar damages even within the 6-year period, and the Supreme Court said no, latches doesn't apply. So at those marginal kind of cases, you're going to get some more money. So there is a little bit more additional reward there from changes by the Supreme Court. But this and all this is a little bit of repeating what that is, but just to lay them out with the names of the cases and the timeline. With some exceptions, we have marched away from stronger patent protection, whether it means harder to prove infringement, harder to obtain an injunction, easier to show invalidity. We moved, or easier to show ineligibility, I guess is the right way to put that. It's all gone one direction, with some cases on the headed the other direction. And again, I'm not suggesting this is some deliberate plan by the Supreme Court. For all I know, every one of their cases was correctly decided. No idea, and for the purposes of this paper, I don't really care. To be honest with you, that wasn't my goal. So what, right? Does any of this matter? Part of the problem is some of these cases are brand new, so we don't know. But some of these happened a long time ago. And when you look at the data, and there were a couple articles written last year, Mark Lemley wrote one, and I forget the other fellow's name who wrote the other. I mean, there were several, but Mark's is probably the most famous. They looked and they said, well, look, the number of patent applications, we had a recession and it went down, but otherwise, more or less a straight line up. Number of patent suits, went up. And Mark wrote, and a really good article. He said the patent system was surprisingly resilient. That's his phrase. With all this stuff, you would have thought bad things would have happened. Some other people said that these are only minor changes to patent law. I don't know if I'd agree with that, but there's debate about it. This was last year, 2015. So I went and looked at the study that Mark had looked at, and what had happened was they said, wow, things have changed. So he looked at the 2015 study. I looked at a study a year later, and I think isn't there just one big accounting company now because they've all merged together? Yeah, KPMG, one of those companies. Mm-hmm. And they said, are we at an inflection point? In other words, are we at a tipping point? And they said the Supreme Court and Congress have devalued patents. That was their conclusion, looking at a lot of what we just went through. The number of U.S. applications, apart from 2008 when we had a recession, it declined last year, 2016, for the first time in a long time, at least since 1982. More applications filed in China than the U.S. There's innovation going on there, but that is an interesting sign that there are more patents being filed in the U.S. there than here. The number of patent suits went down. Again, is that good or bad? I don't know, but it tells me that these statistics tell me with fewer people applying for patents in the U.S., with people who are experts saying we're at an inflection point and patents are devalued, and with the number of suits going down, there is an impact. There is an impact on this. The other thing was that looking at the secondary market, where patent trolls and all that, that has declined radically. The number of patents being bought and sold, the average price has gone down. Intellectual Ventures stopped acquiring patents in, I want to say it was February or March of this year, right? So here you have a big company, sophisticated, making lots of money off of buying patents and using them, says these aren't worth it anymore. That tells me that we're at some change. What's coming up? Well, Congress held some more hearings about reform because it's easy to say these trolls are horrible people. But the second force is to me is the most amazing thing about what we're about to go through or where we're in the middle of. And part of it is brought on by Moore's law, which is the idea that over time the number of transistors doubles every 18 months or 2 years. I forget what it is now. This is the cost of computing. And if you think about it, if it gets cheaper and cheaper and cheaper, and it is becoming exponentially cheaper to develop a new product, what does that mean? Well, the quicker it is to develop a new product, the quicker it gets on the market. That means also the quicker it is for a competitor to get an infringing product on, right? I can look at your product and reverse engineer it more quickly because I have computing power and I have all this capacity. It also means that product life cycles get shorter. And it kind of makes sense to me. If it takes me a long time to develop a product and to get it to market, it'll be on the market longer because it's going to take competitors a longer time to come up with one. And there's an example that let me give you the example, and then it's not going to be subject to all this, but drugs, right? You can't just market a new cure for something tomorrow. You've got to go through an FDA approval process and all of that. But as far as the technology goes, it is easier now for that accused infringer to look at the drug, figure out what it is, reverse engineer it, and make the competing product. There's still regulatory barriers. But technology allows these people to come on board more quickly. So products are going to come on more quickly. They're going to disappear more quickly. And this is funny. I mean, you're younger than I am, but think about some of the things you and I have seen come and go. I mean, 20 years ago, DVDs were like the hot new cool thing, right? Now, I think I bought a DVD last year, but otherwise I push a button and it comes down from the cloud. 16 megs of RAM, that was cruising. I mean, if you had 16 megs of RAM in your laptop, you were flying high. Rewritable CDs. I actually still have a box of them at home. That was the hot new technology. Look at the average time for a U.S. citizen was 30 minutes a month on the internet. 30 minutes, every 30 minutes might be the average now, especially from people like my daughter. Things are changing so fast, and one of the things about Moore's law is that we can't appreciate, as human beings, we can't appreciate how fast this change is occurring around us. But look at this. Patents. How long does it take you to get a patent? Now, it's gotten down, but it's still 2 years. So think about it. If the amount of time it takes to get a product to market is going down, if the amount of time that it will remain on the market is going down, and it takes you 2 years to get a patent, there's a point at which it becomes uneconomical to get a patent because you're not going to be able to sue anybody with it because their products will have come and gone and your products will have come and gone. There's nothing to enjoin for that reason as well. Now, there's some gray because you will have written your claims to try to capture follow-ons, but this whole process is going to happen very, very quickly. The other thing about it is, so I get my patent after 2 years, what's going to happen? You're going to throw it in PTAB. It's going to be, by the time we go there, get it back, we got 18 months that have gone by. So now we're talking 4 years by the time I'm actually in court trying to get my money damages. Now, I'll be able to go back 6 years, but more and more products will be gone during that time. This injunctive relief and the value of looking backwards for damages is going to become shorter and shorter. The final point about all this is 3D printing, and I know a lot of people have written about this, but this just to me was an amazing, also because you can buy them at Lowe's. You can now buy something, and because of Moore's law, with the capacity for computing, with bandwidth increasing so much, you can get a file to make almost anything. And then think about this: if everybody in America can buy a 3D printer and make the new widget that I have now patented, how am I going to spot that? How am I going to get those, realize that that is being done? And here's the ad from Lowe's. I think it was like $600. You buy the 3D printer, and then you can buy different filaments, and you make something. These are plastic. There are things you can make 3D printers, and you get a CAD file. You can make toys, phone cases, guns, guitars. I don't know about the strings. Scary things to me were helicopter parts. Luckily, those are regulated. You can fit perfectly fitting clothes and things like that, belts, things like that. Their biological 3D printing is coming soon. I mean, people are going to be able to print things that are infringing at a push of a button all over the place without you knowing it. And by the way, I have not registered the trademark for CADster, but there's going to be, and there already are, sites that share files to make things. Anything. I mean, you go look and it's amazing the kinds of things that you can see. Now, some folks have said, I like that Tim Holbrook and forget Osborne's first name. They said patent system's dead. 3D printing is going to kill the patent system because why will I get a patent if everybody's going to be able to infringe it and I'm not going to be able to detect it, right? Lemley said nobody's going to have any jobs, but there's going to be lots of innovation, right? In other words, there's going to be this creative economy, but we're not going to be having patents. Instead, there's just going to be all this innovation making all these really cool products using 3D printing. Well, if I'm a patent owner, and just, again, these come to my short-term things, and I'll get to my kind of recommendations here in a minute, but who can I sue? Well, inducement requires specific intent to induce a third party to infringe, not going to be the distributor of the file, not going to be the 3D print maker. Contributory infringement requires that the device have no substantial infringing uses. The distributor of the file, they provide all kinds of files that don't infringe patents. The 3D printer, you can make flowers for your mom on it. Direct infringement. Well, the consumer, the person who makes the product, they infringe. So just like the music industry, you can go sue them. Tim Holbrook and Professor Osborne argued the CAD file infringes. I don't get that. They argued the CAD file distributor is selling the invention, and I just don't get that because the file isn't the claimed invention. And here's what I think will happen when people make these arguments. Right, a court is going to say a CAD file isn't a pipe. Pipe is the pipe that's claimed in the patent, and you're going to have a very difficult time about this. To wrap up, and I know I'm running just a couple minutes over, but I'm at my last little part. What do? Well, first of all, there's track one prosecution. You can get patents issued in months. I mean, sometimes even weeks. I've heard people getting their office action response. It's a little bit more expensive. That's something to think about. There's a way, and it takes some planning, some luck, and some thought, but it's a way to obtain what are called provisional damages under Section 154 of the patent statute. And I've written out in the paper the circumstances where you might be able to do it. It's not going to work all of the time, but it's something to think about. It's a way you can actually obtain damages from publication of your application forward rather than issuance of the patent application forward. Think about drafting product claims to cover things that are in 3D printed forms. I saw one, it actually said a 3D printed lacrosse head comprising. So, include these claims. Again, you're only going to get the person who printed it with the 3D printer, but you'll be sure that you've got that covered. In process claims, include a process claims. Making my device using a 3D printer. Again, you're only going to get the person who used the printer, but you're going to be sure that you got the person who did so. And I would be careful if you got a patent to sue people who infringe using 3D printers. Again, I pointed out that there are arguments that others have made about the file infringes. I don't know about that. The method, you need to really check your method claim to make sure that you've drafted in a way that you can establish infringement, which I think is going to be difficult. And with all that, will patenting make sense? I think my view from what I see right now is in less cases, fewer inventions businesses will find reason not to patent more inventions. How much? I honestly don't know.
Yeah,
I think. Go ahead.
No. Thank you so much. I didn't mean to interrupt you. I thought.
Nope. That's my spiel.
Yeah. No, this is wonderful. So thank you so much for taking. We're a little bit over, but I think we have some time just for some final words if you have any. I guess one question. Lots of things here. I mean, I think I can understand the argument for why the CAD file might be infringing if the CAD file is just another representation of the claims. I mean, I have to go back and look at Tim and his argument. I don't think it's plausible to infringement.
Read it and you see where you come out.
We can go back and forth. I remember reading it and didn't think it too. But one question I had is about China or about other countries. I mean, this seems like largely a U.S.-centered argument about the U.S. system. Do we see evidence that your clients, do you advise clients then to do a PCT? I mean, you obviously do that, but is that more of a focus? Are there jurisdictions that you direct them to? And maybe that's just maybe a good way to end our discussion.
Yeah, I know that some clients don't bother to file in the U.S. because they're going to end up in a ditch. I mean, they're not going to get anything. I personally, my clients have. When I get involved in whether to patent, there's simple things that don't involve huge overseas markets. I do know that from just reading that a lot of the biotech pharmaceutical companies are very worried about U.S. protections and not so much worried about overseas protections, which creates a lot of obviously gray market issues and FDA. They likely have the FDA to rely upon to prevent import and things like that. But if we have a system set up where major innovations in key industries of the future, where those people are thinking it is better to patent overseas and not here, that suggests to me that we have a problem, that the direction, we've made too far of a U-turn. I don't think we've gotten to 1946 yet, but we're heading back towards 1982, and I don't think that's a good idea.
Well, thank you so much. I really appreciate you taking the time to talk. We could talk longer on this, but I think there's a lot of great information here, and we'll have the file up on our YouTube channel in a week or so, and we're glad to share that with you, and hopefully you can direct it to students, and I'm sure a lot of people will this topic. So thank you again, David, for taking the time, and I hope you found it beneficial. I know our audience did, and I enjoyed listening as well. So thanks again.
Thank you. Thank you very much.